So y'all, I'm gonna take a kind of different approach to my co-counsel here. I think just by nature of the argument, all three parties agree this stop was prolonged. The government's response, testimony from the witnesses, the stop was prolonged. Counsel says the stop was prolonged. I say the stop was prolonged. So phase one, I think everybody's in agreement with. The issue is, was the prolonged detention justifiable? Right? The lead case on this is Illinois v. Warley. And I don't even know why there's a bunch of subsequent cases on this, right? In that case, if I pull you over and just so happens there's a drug dog in the area and the drug dog is being taken around the car while I'm simultaneously writing out the ticket for the traffic stop and the drug dog hits, that's not a prolonged detention. If the drug dog isn't there at the moment you pull the car over, then the detention is prolonged. So what we have to get to is whether or not they had adequate suspicion, either reasonable suspicion or probable cause to do so. Now, after the motions were filed, we find out in the people's response that there was this anonymous tip. It's not in the initial discovery. And the court has
I object to that because it's in the video. Deputy Ramirez makes a statement, and if they watch the video, they would hear him say it to Sergeant Hicks.
In his police report, he does not put anything about the anonymous tip as a reason for a stop. And the court should take it, that's why I questioned him on that. And the court should take that into consideration. If he believed that that anonymous tip gave him reasonable suspicion to stop the car, it would be in his report. But it does not, and it cannot. Let's go back over the anonymous tip, Your Honor. The anonymous tip has no specific detail as to how this individual knows there's narcotics activity going on at this Rice Body Shop. They don't say that they personally observed it, that they bought narcotics, that they used narcotics, that they saw anybody else use narcotics at that location. The anonymous tip doesn't even say what type of car these individuals left in, if they even left. So when we have this traffic stop, once the officers are going in the direction of the Rice Auto Body Shop, as acknowledged on cross-examination, they had no information that that car was even at that body shop at the location of this anonymous tip. Now, when you look at anonymous tips, we have Florida v. JL, which talks about the type of detail that needs to go into an anonymous tip in order for it to rise to the level of reasonable suspicion and probable cause. And this anonymous tip does not do that. So the officer pulls the car over for this traffic violation. And it's pretextual, with nothing wrong with that, right? They're using the traffic stop to investigate narcotics, right? So now this is just a run-of-the-mill case you see all the time, whether down in Detroit, Lansing, whatever, right? You got a traffic stop, but you want to investigate drugs because you think drugs have been going on at some other location. What does the officer not do? He doesn't ask, he asks them where they're going, but then asks them where they're coming from. If he'd asked the driver, anybody in the car, where you coming from, and they'd have said Rice Body Shop, I wouldn't even be here, right? But he doesn't ask, they don't say that. What else does the officer not observe? He doesn't observe any indication that any of these individuals are intoxicated, are under the influence of narcotics, nor does he see any narcotics paraphernalia as he's talking to them. So at this point, he has a traffic stop for no proof of insurance and hasn't done anything under the law that allows him to prolong this stop to investigate narcotics. He gets these individuals out of the car, and again, he interviews, based on his testimony, each individual for several minutes, driver being twice. Never asked them, where you coming from? Again, if the answer is Rice Body Shop, probably not here. They don't make any observations, again, of any narcotics activity when they're right there on the scene. And although I agree with co-counsel on his recitation of the law on inconsistent statements, I believe the statements are inconsistent. They are all consistent on the most important fact. Where you going? You taking Mr. Couples back to Traverse City. What's suspicious about that? They're on a roll, you know, that would lead them back to Traverse City, right? So it's not like they saying they're on the way to Traverse City, but they headed towards wherever, you know, whatever city's in the opposite direction of Traverse City. So he's got a story. They're going in the direction of that story, but now he's continuing to prolong the detention, right? The drug dog isn't even called yet until after this second interview of the driver. So now the court has to say, has Officer Ramirez or his partner gotten any information to elevate the suspicion of the traffic stop? If the court agrees with me that the unanimous tip did not rise to the level of probable cause and did not rise to the level of reasonable suspicion to believe criminal activity was afoot to pull the car over, then the court has to now look at, during the valid purposes of the traffic stop, did the officer ascertain any information that would elevate the level of suspicion for narcotics activity? The answer is no. And now we have a denial to search the car. That can't be used. The assertion of a constitutional right, you know, can't be used to elevate the suspicion. So now we calling the drug dogs out and for what? What did he see, hear, smell, or notice to lead him believe that there was narcotics in that car? Because at this point, I think the detention is way past the Terry stop, right? It's not doing anything to fill out the ticket for the no insurance. So it's our argument that he would need probable cause at this point to continue this detention. And there's clearly nothing has occurred to rise to the level of probable cause. Now the drug dog is called out. We have another, you know, at least 10 minutes, you know, for the drug dog to get there. And the drug dog is now searching for what? What did the officer, what information did the officer have to believe that narcotics was in that car? Because, I mean, I'll tell the court about narcotics cases. There could have been narcotics activity at Wright's auto body shop, and all the narcotics could have been left at Wright's auto body shop while they went to Traverse City, right? So they would not only need, there's no search warrant issue with Wright's body shop, right? But they would need some level of suspicion, whether reasonable suspicion or probable cause. And at this point, because of the length of detention, I think we have probable cause to believe there was narcotics in that vehicle. They didn't have it. That's why he asked to search the vehicle. That's why they asked to have a drug dog come to get the probable cause to search the car. And of course, once the drug dog hits, there's probable cause to search the car. So now the court has to say between at what point should the officer just say, you know what, it may be there, I can't get to it, I gotta write this ticket. It surely should have occurred after all three people said, we take couples back to Traverse City. Re-interviewing the driver, you know, ran us in for what? Asking to search the vehicle at that point for what? You know, and so now it just becomes a comfort thing, right? We only here because they found drugs, right? We wouldn't be here if they didn't find drugs, but that's the purpose of the Fourth Amendment. You know, the people that founded this country, they were insurrectionists, they were spies, they were treasonous. They wanted to have a mechanism in which people could commit crimes and be protected from the government. We don't like to say that, but that's the point of the Fourth Amendment, to have some sort of protection, you know, from governmental interference. So people, law-abiding citizens don't need it, right? Law-abiding citizens don't need the Fourth Amendment, right? It's only criminals that need the Fourth Amendment. And the framers of this country, both state and federal, have given them that protection. And I think the court should apply that protection here and exclude the evidence found as search of the car. For exam purposes, I mean, this is a question of fact, so we're not even gonna get to that. Does the court have any questions of me?
I do not.
Thank you.
Thank you. Ms. Carey, any rebuttal?
The stop was initiated at 12:06. Sergeant Hicks was likely called at 12:18. Deputy Ramirez indicated he spent 2 or 3 minutes talking with each person, which he was completely within his rights to do, to talk to the occupants and gather some information. And he did that. He didn't prolong that. He immediately, before starting writing his ticket, got in touch with Sergeant Hicks. So that within 12 minutes after he talked to everybody, and got some varying stories on where they were going and how long they had known each other. And eventually, yes, they all agreed they were going to Traverse City, but it's not where it started. And there were definite discrepancies in what they said and how long they had known each other. And as he was writing the ticket, Sergeant Hicks arrived. So if Sergeant Hicks was called at 12:18, he got there, he testified in less than 10 minutes. He had to travel 3 or 4 miles with relatively no traffic and no traffic lights. It didn't take him very long. We know Cadillac well enough to know that. And then he searched the vehicle in less than 5 minutes with the dog before it indicated. This was not a prolonged stop. And I think based on the totality of the circumstances, given the tip, which again, Deputy Ramirez did not put it in his report, but he did mention it in the video that was provided to defense, that they had received a tip. So based on the totality of the circumstances, the minimal traffic that time of night, seeing the car leaving the area, checking it, if the car had insurance, that would have been that, but it didn't. So they stopped it. And it didn't have insurance. And initially, Mr. Pruitt only handed over his license while the passenger was looking for the insurance. Eventually, the insurance was handed over and they were able to check it and it was expired. But all that takes time, and it didn't take a lot of time. So I asked the court to again deny both motions and bind the matter over.
Thank you. Well, case law tells us that when a court is asked to determine whether or not the length of the stop is prolonged, we don't look at the totality of how long the stop takes. We look at how long it is prolonged from the officer determining essentially that, or from maybe not when the officer determines, but from when the traffic stop should have ended. We've heard a lot about the tip today. Well, that wasn't admitted into evidence. It was testified to that there was no names given, no indication as to how they knew that drugs were being sold or transacted. No description of the vehicle. Essentially, the only thing that we have that would tie this stop to that tip is that there were 2 males in the car and 1 female, and that the female was a girlfriend. And then that was borne out in the testimony that was developed after the stop. The tip came in at approximately 11:51 p.m. The stop was made at approximately 12:06 a.m. That's 15 minutes between the tip being received and the stop having occurred. Now, the court will take judicial notice, because I am familiar with that area, that Wright's Custom Body Shop is about a 1/4 mile on Leeson Avenue from 13th Street. And then, as was borne out in the testimony by the deputy, about another 1.5 miles between Leeson Avenue and 37 Road. The court will also take judicial notice that 37 Road is a road that a lot of people take to go up to Traverse City, up through Minnetonka, Summit City, and the back way into Traverse City. And with a car that is not legally able to be driven because of no insurance, it's not out of the realm that the vehicle would have been traveling back roads to avoid, even though this was late at night, to avoid the possibility of being stopped on 115, which would be another way to get up to Traverse City, and where this stop had occurred would only be about 1 mile from 115. So whether or not they were going to take 115 or go up through the back way, it is at least plausible to the court that the vehicle could have been on its way to Traverse City. So doing some math, we've got approximately 15 minutes between the time that the stop occurs until after the tip comes in. Now, what we don't know is exactly how long or where the deputies were and had to travel to get to Leeson Avenue, or how much time elapses between receiving the tip and encountering the vehicle. That's unknown to the court. But presumably it would only take cars traveling at a normal rate of speed just a couple of minutes to get from Leeson Avenue to where the stop had occurred. Then we have the stop. And while there is case law that says that conflicting stories might rise some suspicion that crime is afoot, that's not the only thing that the court would need to consider. And it has to be a substantive issue to rise to that level. And the officer has to be able to articulate an articulable suspicion, reasonable articulable suspicion that crime is afoot. Ms. Carey cites People versus Williams in her response to at least one of the motions, and I think it was in both, which is cited at 472 MISH 308. The court finds that that case is distinguishable from this one because the inconsistent statement, or the statement in that one case that doesn't make sense, is because that statement made law enforcement was factually just completely inaccurate and couldn't have happened. In that case, the occupants of the vehicle had indicated they were going to, I believe it was Sheboygan, they were going to stay at the Holiday Inn. There was no Holiday Inn in that town. They were going to be there for 3 days, but yet there was no luggage in the car. That rose to that level. The mere fact that while it might raise a suspicion, I don't think it's to a suspicion that crime is afoot, is that they disagree on how long they've known each other or where they might be going or are going to. But when I take where eventually they land on, they're going to Traverse City to drop Mr. Couples off, and they're on a path that could take them to Traverse City, I don't think gets us there. And then when we have the officer testifying that Mr. Couples was argumentative, I asked whether or not that's necessarily uncommon. And he agreed that that was not necessarily an uncommon thing that happens. So then we get to the calling of the drug dog. We know the drug dog is called in at 12:18 based on the testimony today. It takes approximately 10 minutes from Sergeant Hicks' testimony to get to where the stop had occurred. But before that, and telling to the court, is Deputy Ramirez began writing the citation at the time that he called the drug dog. That's the indication to the court that he determined at that time he only had sufficient evidence to write a no proof of it or no insurance ticket. And from that point forward, any amount of time it took to prolong the stop, and outside of the time necessary to allow the ticket to be written. As such, I find that the waiting for the drug dog to be called to the scene unlawfully prolonged the stop, and therefore any hit that drug dog made and any evidence as a result of that is suppressed. So essentially, the search of the vehicle, I shouldn't say essentially, the search of the vehicle is hereby suppressed and any evidence coming out of that. As a side note, I'll just state that when I was a prosecutor, I remember having this conversation with law enforcement a lot about prolonging these stops to wait for a drug dog. And this is a perfect example. Sometimes there just isn't probable cause. Had the drug dog been called at the time that the stop had actually been made, we might be a different story. But where the drug dog's called at the same time that the ticket is began to be written, we know that the file checks were all done because there was only one computer in the car. So there was no reason to prolong the stop longer than necessary to finish writing the citation. With the suppression of the evidence, I find no probable cause to bind the case over. The case is dismissed without prejudice.
Thank you, Your Honor.
your exhibits. And I know that leaves Mr. Pruitt with probation violations. Ms. Carey, do you want time to consider those before we do anything with them? Mr. Pruitt still has probation violations. You may.
We'll let that go.
You're gonna let those go? All right, so the probation violations are dismissed as well. So having those been dismissed, that's the only thing holding Mr. Couples left, correct?
That is correct, Your Honor. He's not going to contest the civil infraction, just in the course of law.
Okay, all right. Okay, so Mr. Couples, at some point you'll be released today.
That's Mr. Pruitt.
I'm sorry, Mr. Pruitt. I'm sorry, Mr. Pruitt. I apologize.
Thank you.
Yeah,
Thank you, Your Honor.
thank you.
You're doing your own man.
Yeah, I'm sorry.
That's okay.
All right,
Thank you, Your Honor.
we are adjourned.
Do you want to remind him he's still on probation now?
Oh, Mr.